Hello, everyone, and welcome to Accessibility News, where we discuss topics about physical and website accessibility. My name is Glenn Ingram. I'm a certified accessibility specialist with regards to online or digital, and I've been working online for the better part of the last 2 decades. Tracy, would you like to introduce yourself?
Yes, I am Tracy Delisle with Certified Access Services. We provide accessibility inspections and educate businesses about the potential ADA violations they may have on their property and help them weather through if someone threatens or files a case against them. But more importantly, we try to promote accessibility within their business.
Bruno.
And Bruno.
Hi, everybody. Hi, everybody. My name's Bruno Katz. I'm a partner with the Wilson Elzer Law Firm, a national law firm that has, I don't know how many offices. I think we have 42 offices throughout the nation, including an office in London. My practice is primarily labor and employment law, but from the standpoint that we're dealing with accessibility issues and ADA violations, we handle those type of questions both from a architectural accommodation as well as website issues, and I've been doing this, for close to 30 years now.
That's great. Bruno, since you said you are with labor law, is there anything that you can tell us in regards to accessibility that comes up for businesses in what you do? Is there any labor law issues that you find happen with disabled employees, or is that something that really doesn't happen?
No, absolutely. I mean, there's a duty under the law to accommodate, at least engage in what's called an interactive process. When you have an employee that puts you on notice of a disability, you have either through the application process or if they get injured while they're on the job, you have to engage in what's called an interactive process. And that's basically a conversation that you have between the employer and the employee as to what the accommodation is, what the disability is, what the essential job duties and responsibilities are, and whether, based on the essential job duties and responsibilities, you can provide either a temporary accommodation, if this is going to be a temporary thing, or a more permanent accommodation. But you at least have to have that conversation. There are certain jobs and duties that, depending on what the disability is, for safety reasons, you couldn't hire someone for that, because if, like, say, for example, if you were in a safety sensitive position where you have to drive heavy machinery and you have a uncontrolled seizure disorder, that could be a safety hazard, not just to you, but to the employees. So that would be, or if you're in a safety sensitive position where it is a requirement that you have clearance and you're able to operate things without that kind of an issue, such as in transportation or trains and things like that, that you have to be able to run it. You have to have those conversations. And sometimes you can temporarily accommodate them, but sometimes you can't. But you at least have to have the conversation, and it has to, and that includes, oftentimes disabled employees will bring a doctor's note and tell you, well, they need these additional breaks, or they only can lift this amount for this amount of time. And as long as it's a reasonable accommodation, you need to accommodate them. But you don't have to accommodate any accommodation or any thing if it's not reasonable and they're unable to perform their essential duties. But it's very important, because if you don't do that, if you don't have that conversation, if you don't document what's going on, and if you don't deal with that, you're facing yourself with a potential disability discrimination claim. And so that, and also from an accessibility standpoint, I mean, disabled people, you can fix desks, you can fix pathways, and you have to do that anyhow so they can get around and do things. And oftentimes it's not that expensive, and it's an easy fix to do. And there are resources out there. I'm going to tell just a quick story here. I was at a conversation at a hospitality conference, and I was on a panel, and there was another individual who was going to be on the panel who was a disability attorney expert, and that person came from more of an advocacy and helping both employees and employers. They were kind of neutral, and they were an attorney, and all I knew was that person's name. And then I showed up at the conference, and this disability attorney, lawyer that works for this, organization. It's kind of a neutral organization, kind of give details on ADA and everything. She had no arms, she had no legs, and and she was probably, based on what I heard, one of the foremost people that understood this. And I mean, she was in a wheelchair. I mean, she got around, she did everything. And so and she talked about reasonable accommodation. She talked about unreasonable accommodation. So what it says to you is disabled workers are, can be wonderful workers, and you can do reasonable accommodations for them, but sometimes you can't. But, there are jobs and positions, and people can be very successful no matter their limitations. And here's this lady with no arms and no legs, and she's, one of the forefront advisors on people on ADA. So it's just it's kind of an inspirational thing. And she was great because she was able to explain in no uncertain terms the what is an unreasonable accommodation. And so she even understood that. And of course she did. But I mean, that really, it comes from her. It's very powerful. So.
Absolutely, because she's kind of setting the precedence of when you look at someone and it's not, you feel like the motivation may be slightly different. You're all of a sudden going, well, look at this one. I mean, talk about her disability, and you would think, what could she do? And she's out there and she's doing it. So she's proving that it can be done. It's, the will and the intent of, the person that's claiming the disability and how far they want to go with it. So I've seen some really great stories of disabled, they really want to work and they really want to be independent. And when they work for somebody who wants to accommodate that, boy, they tell everyone and they're really happy with where they are. So I've seen that over and over again. It's not all about the horror stories that we hear legally, but there are a lot of great inspirational stories that certainly keep me and don't let me complain, right? It's like, okay, I got a whole lot easier. I have nothing to complain about because they're not complaining. So yeah, I love those stories. Love, love, love.
Well, and I think that we always hear, anytime you have something in the news, you hear the small percentage of people that are getting a lot of attention. From my aspect, and a lot of the disabled people I speak with on a regular basis, they want access, they want equal opportunity. They're not out here suing for it. They're trying to promote it, talk to people about them, educate that, so that they can have the same access that you and I take for granted.
And how powerful is her message that she's coming from both sides of it? She can sympathize with someone who has a disability, but she can also understand that there's a way to make it work. So that must be a great person for you to refer to, Bruno, when you're trying to help the employer, deal with an employee who has that. I mean, she's got to be imagine she shows up and you're in mediation or something. She's mediating through that, holy moly. You'd be like, okay, you win.
Right.
So,
right.
Yeah.
And so, so it's an interesting, she's a really great lady. It's really kind of inspirational, and she can really, she's great at saying, oh yeah, this is a problem or this isn't a problem. And she'll tell you, oh no, you don't have to accommodate. I mean, people are giving out scenarios about, well, do you do this and this? And they go, no, that's not reasonable. And that's not a fair accommodation given what it's in. I mean, you certainly, an employer doesn't need to bankrupt themselves, but a reasonable accommodation so that, simple steps, and sometimes it's not that complicated, a seating chart or a certain attachment to a desk or a chair or this can easily be done. And the expenses are not outrageous. So that's that's why the interactive process is critical. And that's where sometimes employers trip themselves up, as they engage in that interactive process in a way. They say, well, the person's disabled, they're unable to get their essential job duties, but they have to, most employers do this, but they have to have that discussion as to what the accommodation is, and then determine whether that's reasonable or not. And you do your best, you err on the side of trying to make it reasonable. But if someone can't do the essential job duties and become permanently disabled because of an injury, and they, there's heavy lifting, you don't have to find a different kind of job for them. You have to, and if you don't have a job opening that you could put them in with that accommodation, you don't have to keep them on for that. But that's, it's always tricky, because disability is probably, the fastest growing area of the legal claims on employment standpoint going on. Everyone talks about sexual harassment. The reality is disability is probably the one that is growing at a faster pace than any other one, to be perfectly honest.
Do you put part of that into maybe statistically that we have a population right now with the baby boomers, older, and so with aging increases disability, or are you seeing that there's something else that's trending that uptick in disability lawsuits?
Obviously there's a component of the baby boomers getting older, but the disabilities that I see and the claims that I see are not from workers that were the baby, that I would say majority from the baby boomer generation. There is definitely the younger generations, the millennials, the Gen Zs, to some extent the Gen Xers feel like, and they're more vocal about announcing that they have an issue or they need an accommodation, whether it's reasonable or not. And that's not an indictment of the generation. They're just much more attuned to the issue, and they're aware of the issues on disability accommodations. And it's really the younger workers that we see this more often. And there is definitely, it's a different mindset. The older generation sometimes will gut out things that maybe they shouldn't. I don't know why that is, but they do that. But some of the younger generation, if there's something that they feel like they can't do or they're not able to do, they're not shy about letting the employer know that I have a problem. And some of the, obviously there's people out there that are taking advantage of the system. Most people probably aren't. They have medical notes. I mean, sometimes it becomes problematic where you say, well, okay, you say you can't do this. I need your doctor to give me so I can engage in this interactive process. What can you do? What can't you do? What are your limitations? And sometimes there's pushback from certain employees, and this goes across all generations, and say, well, I can't get a doctor's note. Well, that's really not reasonable. You usually can get in a doctor, and the doctor can tell you, a medical provider tell you, well, I've examined this person, even if it's a stress-related issue, that because of this, they need additional breaks. And people are not shy about asserting those rights. And I think that's why the uptick is that there is definitely a sense, whether it's a generational sense or it's just people are more educated, not being afraid to tell your employer that you have a disability or you need an accommodation and you can't do this. And obviously there are some people, there are always some people out there that, know and we see this often. I'm on the employer side, not often, but enough, that there are people who are claiming disability because they know they have a history of serious performance issues, and they're probably on the verge of getting terminated. And all of a sudden, magically, they're filing a disability or a work comp claim. So that does happen. And it's not uncommon to see in the cases that I litigate that you see that happen, is that there's a person that comes in with that and makes that claim. So,
yeah.
Now, you mentioned litigations, Bruno. Have you seen any new trends or any new things that are happening in 2021 with regards to ADA or UNRUH lawsuits?
I think, what I say, I think the trend is definitely less from the architectural standpoint, the traditional physical architectural standpoint. I mean, we're seeing those, particularly with the temporary structures that have been built when people were trying to do outdoor dining. But website accessibility has been, and I think this is just a continuation, the claims of accessibility to the website or language on the website seems to be continuing to grow in litigation. Obviously, we still have the architectural, Article 3 issues where your bathroom door isn't wide enough. You don't have an accessible entrance. Your parking lot isn't graded properly. You don't have your handicapped parking spots, or if you have them, they're not big enough. I mean, you don't have a van accessible one. We do see those, but the websites are definitely the cutting edge. And as you guys know, when the ADA was passed back at George H.W. Bush's presidency, we were in the, the internet was, if it was there, was in its infancy. Nobody thought about these things, about accessibility websites or anything. So there is nothing in the ADA language, and it hasn't been amended since then, that really has provided guidance. So there isn't a clear standard on, there are standards that have been put out by WGA, but it's not in the ADA itself. And so they utilize those by saying the website is not accessible. I can't, if I click on an image, it doesn't describe the image, so I don't know what is there. Or so it is a kind of, but the courts have been, especially where we are, and then in California Ninth Circuit, have treated the ADA very strictly and expanded it to provide fairly strict standards on website accessibility. Other places, because if you don't have a physical storefront, have been more lenient. Other courts have been more lenient, but California has not been one of them.
Right. Go ahead, Glenn.
No, I'm just saying, it kind of surprises me when you look at the current administration and how quickly they were out there boasting about their site being accessible where the previous administration wasn't. It's really surprised me that the DOJ hasn't literally just taken the documentation from 508 and moved it over to Title III. What's your kind of perception on that, and what do you think about moving forward, what we're going to see with that, Bruno?
I think the administration and the Biden administration priorities have been, I don't think ADA, DOJ issues have been their priority. I think the DOJ is caught up in other issues that they think it's higher and more important than providing clarity. I mean, I can remember having conversations with elected officials during the Obama administration about things, and during the Trump administration about things. I haven't had any conversations, now that the Biden administration is, but none of them, everyone says the DOJ is working on it, the DOJ is working on it, the DOJ is working on it, and nothing's ever happened. So maybe something will happen under this administration. I don't know. I just don't see that is a high priority for them right now, but I'm obviously not inside this administration and the current Department of Justice.
Right. What is it when people file these cases on lawsuits, what do you see is the main item that they're looking for? Like specifically, is there one specific item that you seem to see on all the lawsuits that they're looking at that's causing it?
From an architectural standpoint, I mean, the typical ones are the parking.
Oh, I'm sorry. I meant on a website. I'm sorry.
On a website? The website ones that we see are twofold. One is the pictures themselves don't have, when you click on this pictures and you have the software, if you're visually impaired or hearing impaired, that they don't have the bells and whistles on them that they translate as to what the picture of. For example, any picture that you have on a website is supposed to, and Glenn does this for a living, is supposed to describe what it is. So if it is a picture of a bedroom with a king size bed with lamps overlooking a pool, it has to have the ability, based on the readers you have, to make that determination. And so that's usually what they're alleging from a website accessibility, is that doesn't meet the WGA standards in order to do that. The other thing that we're seeing more and more on websites, and this more has to do with hospitality and hotels, is they're saying the descriptions of what ADA accommodations there are in rooms. Like they're saying there isn't enough description as to the, if you have, are there ADA,
like a roll-in shower or
like a roll-in shower, like, grab bars on toilets, issues of changes to beds, so people that are wheelchair accessible can't do that. That check-in, ADA check-in accessibility, when you check in, you need to have all of those things, that if a disabled person can check in easily. For example, the counters not being too high for somebody. Those all, and that's nothing new. People have been, hotels and hospitality have known that it needs to be implemented, and obviously we have technology now that you can have contactless and check-in, and you really don't have to see a live person. There's a way to check yourself in and then pick up your key card, or have an electronic key card on your phone so you can get into the room. Obviously, the older hotels might, are implementing that technology, but from a website accessibility, it's really the reading, the ability to read the website is the big thing. And obviously, the arguments, and Glenn knows this from an e-commerce standpoint, where you don't have a physical storefront, how is that really an issue? How are you not encountering accommodations? And that's what's been litigated and successfully in other jurisdictions, just not California. Some jurisdictions successful, some not so much.
Yeah, as I say, we are crazy here in California, and I can say that because I was born and raised. So we're crazy Californians. It just is.
We have a great $1 million question from LinkedIn. How do you define reasonable?
Well, that's a fine question, and reasonable is defined is what an objective person, not a subjective person, when an objective person looking at the issue would think was reasonable. So it's kind of a community standard standpoint. But you need to, reasonable has to do with, from a website standpoint, it's, if you're following the WGA guidelines from a website standpoint, those are reasonable. As to the write-ups themselves on there, there's very little guidance from the Department of Justice or anybody on how descriptive that has to be. And so therefore it's really subject to interpretation. And the problem is with these websites where it's saying you don't have enough of a description of what's going on, you can have two interpretations, but the question is you may be right, and you may have meet your standards under the ADA as to your descriptions of the rooms, the accommodations, the roll-in showers, the width of the accessible bathrooms, the bedroom issue, the toilet issue, the sink issue, the mirror issue. You may have enough descriptions doing that, and you may think it's more than reasonable, but the plaintiff's attorney who's bringing the litigation is saying, well, you need more detail, but they won't tell you exactly how much more detail that is. They'll just say it's not enough. And the problem and the quandary that the business has is, I can litigate this thing and I may darn well be right. My descriptions may be enough based on how the ADA defines it and based on the DOJ guidance, but how much is that going to cost me to win? And if I lose, I'm subject to attorney's fees.
Right.
So it's probably cheaper from a business standpoint, 9 times out of 10, to settle these things than to litigate them. Now, are they litigated occasionally? Sure. And if you have serial litigants that keep filing these over and over and over again, the federal courts, sometimes see that the serial litigants, and they have to do an extra step and file a declaration as to why this is a reasonable case. And this isn't just one of 50 cases I just filed to get over that hurdle. I know the Central District Federal Court requires you to do that. The Southern District I haven't seen that, which is the San Diego one, and that's where I am. But I know that the Central District, which deals with LA area, Orange County, Southern California area, does require you to submit a declaration if you have filed a certain amount of these cases to declare this is the issue, this is what I find. So it becomes more complicated. Now, reasonable accommodation, that's based on the conversation you have with them. What's reasonable is if it's not unduly expensive. What's reasonable is if you can do it in a manner and still have them be able to do their essential job duties. And not reasonable is putting them in a different job that they're not qualified for and they weren't hired for. That's not reasonable. And what's also not reasonable is spending a lot of money just to make that would cost with specialized devices to make just them do that job, as opposed to some money. But I mean, if you're talking about spending hundreds upon hundreds of thousands of dollars just so they can do the job, that's not a reasonable accommodation. That wasn't what the ADA was meant to do. Hopefully but reasonable, it really is a case by case analysis, and you really got to have the discussion with the employee to see, if you're dealing with an employer accommodation issue. And the medical professional, all you can get is that you can't delve into their, deep down into their medical history. All you can say is that this is what they have to accommodate. You can get general stuff, and you have to keep it confidential because there's HIPAA issues, and you have to keep it very limited into that. But you need to document. Documentation is the key in any litigation. If you document that you've done certain things, you're in a lot better stead saying than a he said, she said, she said, she said, he said, they said type issue.
Yeah, I agree with that. Bruno, talking about the lawsuits, what is the average lawsuit settling for with websites right now? I mean, that's when somebody is trying to decide, how to fix it, what they're supposed to do, or, when they get hit with a lawsuit and now they've got to settle with them and now they're going to have to fix it. What is you're seeing? I know average is kind of a hard thing because it really depends on who's filing the claim, somebody who's very experienced in it and somebody who's maybe not. So what would be something a business would expect when they are hit with these lawsuits in regards to settlement? At the end of the day, I mean, attorney fees, everything. What is something a business would expect? A small mom and pop. Well, let's start with that.
Sure. Well, it is very dependent on which plaintiff's firm has filed it. Some plaintiff's firms file these and they're looking for, under the Unruh Civil Rights Act, it's a $4,000 per violation unless you do certain, and this is not so that $4,000 is kind of the starting. An experienced lawyer is going to say, well, it's at least $4,000 plus my attorney's fees. There are some lawyers who will settle for less than that because they know they're just a serial litigant and they know if they can get you for $1,000 or $2,000, they can maybe get 100 of these because nobody wants to spend that on attorney's fees. Then there's the other who've been doing this for years and years, 20 years plus, that are going to say early on in litigation, we're not going to settle for $4,000. We're not going to settle for $6,000. We're going to settle probably somewhere between 12 and 16. And if you can do that early, then your attorney's fees aren't going to be huge, but they're still going to be a couple $1,000s. So when you're dealing with that, it can be, if you're settling, like there's a very experienced firm that we all know about, where if you settle early with them, I can pretty much tell you that the best case scenario you're going to get out of this is $12,000. That's probably their soft spot right now. And then with attorney's fees, then you're looking 3 or 4, maybe 2, maybe 3, maybe it depends on how long this drags out, 4,000 if you have to do a little. So it can be, $20,000 endeavor early on. Now, obviously it gets more expensive if you go into discovery, if you do have to produce documents and then you settle for $12,000, you could be looking at, $25,000, $30,000, $35,000, $40,000 if you're litigating this heavily. And through trial, obviously, it's much more expensive. And then if you lose a trial, you have the prospect of, and the reality that you're going to pay the other side's attorney's fees if they find a violation. And that's what really drives this, because under the ADA itself, there isn't a set penalty. There's like actual damages and attorney's fees. Yeah. And actual damages might be nothing because they never actually went to your place of business. They just noticed it and said they couldn't bill. And so were they actually damaged? Probably not. What drives this is if you do get hit for the violation and you have to do the remediation, you're facing attorney's fees. And attorney's fees, if you're litigating this, can be $50, $60, $70, $100,000+ that you'd have to pay. And it can be more than that if you fully litigated it. That's why these cases, everyone says these are shakedowns, and they really are, because the cost of doing business it's going to cost you less to settle it more times than not than to litigate it, even if you're in the right. But if you're in the right, there are cases where you're in the right, where you have had a certified access specialist certify from an architectural standpoint, you're 100% in compliance. Or you have the certification of the WGA and you can prove that. And then you can say, look, we've got this documentation, drop the lawsuit. And I've had that happen a couple times because they just go down the block and they hit everybody. There's something wrong. And they'll say parking lot, they'll say bathroom, they'll say pathway, they'll say table size, they'll say counter size, and you can go, well, what do you are? And some of it's valid, some of it isn't usually because they just slap it all together. But as long as they hit you on one of them, then you've got a problem. that you might not be in compliance. But if you have the certified access specialist, the CASP, on an architectural standpoint, that's done and posted in your window, in theory, that's good for a year where they can't get you. So that's why prevention is important, that you make sure that you have a CASP that has examined you and knows you're bulletproof, or you have your website checked out and certified by a specialist. So those are the best defenses.
Glenn, I have a question for you really quick. Our guest just heard those very large numbers that they can get hit with those lawsuits. I think hearing it from a lawyer and the numbers that are actually happening, when someone goes in to get their website fixed, we've often said that, sometimes it's cheaper for them to just start all over again. What is it that you're doing outside of the WCAG that a lot of people don't understand that's making it compliant? Is that reader thing that Bruno was talking about? Is that what you are doing? That's like what you're doing to help them that maybe some of those buttons aren't doing that we talk about? What is that?
Yeah, the only way to make a site truly accessible is to do it at the code level. So when you have a screen reader, the people that built screen readers used different language than what most websites are out there. That's why 98% of websites right now are not accessible, because you have to not only understand your typical HTML and CSS, you have to understand some things called ARIA, which I think is HTML 5.7. You have to understand semantic HTML, so that, like Bruno was talking about, when you have an image there, you have to paint a word picture. But you also have to understand the way a screen reader peruses a website, kind of like you or I would have perused a newspaper and looked at different titles or different headlines. If your headlines aren't structured properly by using semantic and by using ARIA, then you're not going to be able to use the screen reader properly. So it's the only way that I know to do it is to do it from the beginning and to make it completely accessible so that it works for everyone, regardless of their, I say, ability or disability. Because you may have someone that's blind, but you also may have someone that's colorblind. And if there's not enough contrast between the foreground or the background and the text, then they can't read it. And 9% of us men are colorblind by the time we're 50. So you have to kind of make sure you understand the entire scope of different disabilities. You have to make sure that it covers, the current stats we're seeing are somewhere between 1 out of 5 to now maybe 1 out of 4 people has a long-term disability. And even though most of the lawsuits are talking about blind people or about deaf people, you still have a lot of people with MS or MD that can't navigate a mouse. So if they can't navigate a mouse when they come to your website, especially like an e-commerce site, and they can't purchase, well, you're losing that percentage of that little disability and this percentage of a disability from becoming a client to conduct commerce. Along those lines, there's some of us have been talking about this a lot for the last couple of years, Bruno, and this really seemed to be top of mind this year. And there was actually an article on NBC News just last week about people that are blind, advocates of people that are blind, really going after these overlays that not only don't correct everything, but more often than not provide other types of obstacles. Are you hearing much about overlays and things like that in the suits that you're seeing with regards to website accessibility?
I hear a little bit about the overlays. I'm not a technical guru when it comes to this stuff, but they do talk about, well, you may have done this, but the reader doesn't work. And therefore, what we're reading, you may have put this in there and it may work under your system, but it really doesn't work under his system. So or her system, so they can't see it. So as I understand and been educated, that some of these measures that we think could have been done and were stopgaps really don't take care of the issue. And I haven't had to dive in it so deep to really test it, because ultimately we were able to settle all those issues on the websites, because most of the website stuff I've had, the settlements have been so low that we were able to get it done. But what I made clear to them is they needed to get a real expert that can go through their website and make sure that the issues are compliant, and some of them invest in that and some of them don't.
And I think what business owners need to, I'm sorry.
That's all.
Well, I think what business owners should understand about this is, at some point, people that are filing these lawsuits are going to communicate with people that do what we do online. And what most people don't understand is how techy and geeky you can get with this is each of these little overlays creates what's called a footprint. So we all have or a lot of us have tools we work on lines to, when you know a footprint, to put something in a computer, and then all of a sudden, boom, we know every of the, whether it be 10, 100, 1,000, 5,000, 10,000 websites with this little piece of code on there. And now for people that are serial litigants, they can simply go after all of these because they know that this from precedence isn't accessible. And now we have a target to start suing people. So sometimes doing something that you're not completely familiar with can provide a lot more harm than good.
Yeah, I mean, listen, Glenn, I certainly get the calls and they say, I've got somebody who said it's going to be $19.99 a month and it's going to put this little accessibility thing on it. And I get it. I mean, it's tough right now for business and people don't want to spend the money, but I certainly wouldn't want to give, $12,000, $14,000 to a serial litigant, which, by the way, you can get one suit right after the other from these people. And I know somebody right now that's got 4 of them because they didn't realize they really needed to do something. They just kept settling. And by the time they spent all that money, they could have created a brand new website or fixed their architectural thing with all the money they had to settle. So I get it. People don't want to spend the money. But it's kind of like, if you don't, you're going to end up paying lawyers and you're going to end up paying these serial litigants for a settlement, or you're going to finally get it right. So they force you to that.
Let's take a look at that word advocate, because the more you communicate with people in any of these little subsects of disability, so whether it be people with vision issues, people that are in a wheelchair, people with MS or MD, they're pretty tight-knit communities. So just take a look at this as a business expense or an investment in your business. If it costs you $4,000, $10,000, whatever this fee is, how many of these people that are in your community that are suffering from one of these disabilities, once they know you're an advocate, will come in, conduct business, purchase from you online, and now you've opened yourself up to people that weren't clients prior to this, and it's going to pay for itself, and basically you're doing what's right along with it. So there's a little bit of heartfelt benefit from this as well.
Absolutely. Listen, Janine Stanley, last week, our guest, was a perfect example of, she's like, if I find a place or a site or something, I'm telling all my friends. I mean, it's just, we do the same thing. You find a great restaurant, I'm going to tell you where it is. If you have a great experience somewhere, you're going to tell your friends, and they are a very tight-knit community, and she promotes when she can find a place that really accommodates her disability, for sure. So yeah, definitely don't miss out on that business.
I saw there was another question. Someone says, anything you can do if it is their attitude that makes the person disabled? And that's that's a great question. So attitude is not a disability. If you have a bad attitude and you're mean to your fellow employees, that's not a disability, unless some doctor says that you have Tourette's or something like that, and that your random swearing is because of it. But someone who has a bad attitude is not disabled. That's a bad performer, and you need to document their bad performance. Now, do people have medical conditions or psychiatric conditions that sometimes cause them to act out? Yeah, they are. And if they have that, then they need to provide medical documentation that as to a disability. But that still doesn't mean that there aren't ways to control that. And so you need to have that conversation. But a bad attitude itself, that's not a disability. There can be stress disabilities. There can be disabilities because of PTSD. Those can be disabilities where things like that, other psychiatric conditions. And then you have to have that conversation and discuss it. But a bad attitude itself, and that's why I say it's a case-by-case analysis. Just because someone says, well, I don't like working for you because I just think you're too tough on me, you have too high standards. Well, as long as your standards are fair and reasonable and aren't discrimination against the person based on disability, race, creed, sexual orientation, their identity, gender expression, military status, veteran status, I can go on and on. We have a lot of protected classes. But as long as you're not doing that and you're not retaliating against them, just because they have a bad attitude doesn't mean they're disabled. Can you countersue for frivolous or serial suit? Yeah. Frivolous litigation is a very high standard. standards, very high standards as to who is a frivolous litigant. They have to lose a certain amount of cases, and those cases have to be determined as having no merit before they're malicious, or they file something that has absolutely no basis on facts and data. But a court is going to err on the side of caution before they find someone to be a frivolous or litigant. They're going to go out of their way and look at it. And is there any way that they could have alleged this claim, or is it just there's absolutely no fact interpreted in the light most favorable to them? That's the only way you're going to get a malicious lawsuit or a frivolous lawsuit. Like I said, there are some courts that where they see the same litigant again and again are requiring they have to do certain declarations, and that's an additional hurdle. But a good plaintiff's law firm will know how to get around that hurdle. Maybe not a good plaintiff's law firm won't. And that's where you sometimes get those victories, is where somebody is just going down the block and hitting everybody. And then you provide information and show them, and you say, you have two choices. You can either dismiss the case, because I can show you the measurements of my parking space, are van accessible and painted properly, and they're in the right, and they're graded properly. You need to dismiss this case. And oh, by the way, I had this one. Oh, by the way, we're not even in charge of this parking space. Someone else is. And you're complaining our disabled parking spaces are completely great, but you went across the street and parked somewhere else. Go sue them. We're not in charge of those, even though we say to you, other disabled parking's over there. We're not in custody. So that can trigger a potential frivolous or a lawsuit.
Well, and when we look at these settlements, Bruno, what's a ballpark average of the attorneys that are on the plaintiff or the defendant side on this, as far as average hourly fees in the state of California right now?
From the plaintiff standpoint, they're probably going to claim high threes, low fours. Sometimes they claim more. From a defense standpoint, it depends. Some defense firms are defending it in the twos. That isn't where we are, just so you know. You're going to be talking mid threes, sometimes a little less, sometimes fours, depending on what the law firm is. There are some law firms in other areas of the country, probably New York City, Los Angeles, other maybe in San Francisco high rent district, who are going to defend you. They're going to say, well, my hourly rate without insurance is going to be in the fives, $500 plus an hour. It really depends on the firm. But if you're doing an insurance rate, if there's an insurance company that actually defends this, you're talking, with your deductible, they're probably going to cap out the attorneys that they do hire somewhere in the mid to high two rate for partners. But if you're paying out of your own pocket, you're going to be paying you probably can get some lawyers for that. But in this day and age, you're probably talking in the 300s, low, mid, even sometimes high 300s. So
the reason I ask that is just so anyone that sees this can just kind of put a pen to paper. If you have 10 hours on both sides, 20 hours times 350 is $70,000. If you get the 40 hours total, you're looking at $14,000. So it doesn't take long for this to add up and just affect your settlement.
That's why I say fast and furious. Like, you want to deal with this fast and furious. You do not want that ticker going by any means. I would love to talk to you a little bit about the parklet situation, because it is a hot item right now for all of the architectural elements that are out there and the lawsuits that we're seeing filed. And Bruno, my question is, all of these businesses, threw these out there and put them up. The city said yes, and the parklets are the ones that are specifically on the streets that I'm talking about. And there wasn't a whole lot of instruction on what they needed to do. It was bare minimum. Let's try to get some business going. But now that they're looking at extending times, the city or the local jurisdictions are looking at and saying, okay, well, now we want you to be able to keep them up for a bit longer, because we want you to still generate that revenue that's been coming in. But now we want you to bring them to the current standards. So I'm finding that people aren't understanding that, yes, you did get to put them up, but bringing them up to accessibility seems to be the number one thing right now that people didn't do. They made a structure that it was okay. It might need a few things to change. The fire department definitely came by and said, we hope you're not going to make this little bonfire out here. So that's fine. But accessibility seems to be the one that people are having the hardest time with. And is there any advice that you would give legally to them? Because what we're hearing is that the cities are going to say, if you don't bring it up to compliance, we're going to force you to take it down. And that's the scare of everybody. It's not everyone's going to have to take it down. Some people actually went through the city. The city approved them, but it's really not compliant. So what from a legal standpoint do they say? Well, the city approved it. What,
Right.
now they're making me change it.
Right. Well, I mean, the city may have approved it in emergency measures, and I think you've seen some of these lawsuits. Some people still brought an ADA lawsuit saying that, well, it is extension of your restaurant, and so these parklets, you still needed to have the spacing, you still need to have accessible tables, you still needed to have the pathways sufficient that a disabled person could do so. Some of those lawsuits were brought, and the reality is the ADA is a federal claim and unruh civil rights is a state claim. And honestly, if you put it into court and you weren't in compliance with unruh and ADA, even if the city said you're okay, there's an argument that you aren't in compliance and they might have a claim. Maybe the city, if the city gave a waiver and said we could waive it, the question is that waiver valid or not? So, I mean, the advice that I would put, if you're continuing to have these parklets and issues, you need to make sure that they are in compliance with the ADA. You got to make sure you have accessible. I mean, I think of restaurants in the ones, but you have to have the accessible tables. You have to have sufficient space. You have to have a that is such that a disabled person can easily access these issues. You have to have the ability to do that if you're going to be allowed to keep those up. So you do need to make them ADA compliant. And the best way to do that is to actually get somebody who practices in the architectural standpoint, goes out there and looks from an ADA standpoint. I mean, some of these parklets were put on top of ADA parking spaces.
They were.
They were. And maybe that worked. And I mean, I know of a threatened lawsuit that they were put on top of the ADA parking space and they really couldn't do that. And the landlord basically said, you got to either take it down or you got to move it over. And the city was like all supportive of the operator and said, yeah, you probably just need to move it over a little bit. But when you moved it over a little bit, the grading was such that maybe it wasn't ADA accessible.
Right.
Maybe it was graded not appropriately. And they're like, well, I did everything I want. The city said I was okay. And the city's fine. Yeah, we're fine. You are okay. But the landlord's like coming down on the tenant.
Yeah.
And it's not the people going, it's the landlord. And landlords, and they've used that as leverage to try to access additional rent, additional other things that have gone on. And so everyone's hurt. The landlords have been hurting really bad. Obviously, the tenants have been hurting bad. The landlords are, that's a whole nother component of that commercial leasing is very problematic, but that has nothing to do with ADA. But you're going to have to be in compliance. You're going to have to, if it's going to be a permanent thing, you're going to have to get up to standard or else you're going to be facing litigation. You're going to have a CASP come out there, a certified access specialist, and make sure you're spacing the tables out. Make sure the pathways are sufficient. Make sure you have an ADA compliant table, depending if it's a small little thing that somebody has a table that a wheelchair can go under and they're not blocked. So you're going to have to do those things. And that's the reality.
I see that one thing that they're really missing too is the path of travel from that structure to the restroom. And so we're adding that into that piece for the local jurisdictions because, they've stacked up furniture, in different areas. They've really they've reacted. And now as they're going back into work, they're forgetting that they still have to keep that path clear. I mean, so they have to be able to get from the structure to the restroom. So that's one thing that we're seeing that has changed.
Oh, absolutely. I guess you could close the restroom, I guess, in theory, if you, say we don't have a restroom. I mean, maybe that's an option, but I don't know.
I don't think they can if they serve alcohol though, right?
Right. I know.
Yeah.
I'm just like,
Yeah, I know. I do the same thing. I mean, it's a toss up. Are you making more money there? Or I do the same thing. Yeah.
Right. But if you do have a restroom, you definitely have to have the path of travel be accessible.
From that structure.
From the structure. Right.
Yeah.
And you have to have signage showing it.
I know. Yeah. I appreciate you talking about that a little bit, because that is something I'm really trying to stress to people, that it's changed, but we're here to help them and help them understand that and get them through.
One question I've seen a lot over the last year or so is is there a difference, and let's share if it applies to physical and websites or both, between the time from a demand letter versus the time with actually lawsuit being served. So if you get a demand letter, let's say for physical or website, and can fix that prior to that time expiring and actual suit have not been filed, no filing fees and stuff like that, does that affect your negotiating stance and what you pay out if you can correct it prior to that 30-day notice?
Well, definitely from an architectural standpoint, under the Unruh Civil Rights Act, once you get that notice and you fix it, and you can show you fixed it, and they do still go forward and file the lawsuit, you can argue that you reduce. If you're a small business, you can argue that the Unruh Civil Rights goes from $4,000 to $2,000 per violation. So that always, and here's just a general reality, is if you can settle litigation prior, if you can settle claims or litigation prior to an actual lawsuit being filed, usually you'll be paying a little bit less money, because they won't have to pay the filing fee. And here's the reality: is somebody else, in theory, if you're filing an ADA lawsuit based on website or based on architectural, they should have had an expert report that have already told them what the issues are. And I think most of them do, but I think there probably are some litigants there that says, well, let me just throw this on a piece of paper. I really haven't hired an ADA person. But the good ones, the ones that, when I say good ones, they're not, they're all, it's a relative term, let's put it that way. The people that dot their I's and cross their T's, and it's going to cost you a little more to settle, will have someone in the background, a Katz certified person, or a person that understands from a technical standpoint, the WEA standpoint, that has run through the website, has run through the issues, run through the overlays, run through the readability issues. And from the accessibility, you'll have a Katz person who has run through all the issues and has identified actually where the deficiencies are. But there are law firms out there, and we know who they are, where they'll throw this out and say, okay, well, you pay me, which, these are the ones that say, pay me $1,000 or $2,000. And
right.
And then that, for that, it makes sense to settle because you're going to spend a lot more. Or maybe it doesn't. Maybe you challenge them and you spend a little bit more money and you prove that you're in compliance. But you pretty much can tell who if you're settling for a very low amount, that's probably someone who hasn't done their homework. If you're settling at a higher amount, that's someone who probably has done their homework.
Right. And once you settle, if you haven't had your own CAS inspection person come in and identify, you're really subjecting yourself to another one coming right behind it. It's just how they're operating right now. And we saw a funny one the other day, and you don't see too often, where they actually include pictures of the business with that lawsuit, and they did it, and it was a completely different business. So I always say, make sure that you read through. Don't just read that first page and know that now you're in a lawsuit. Look through, because it may not be your business. He's like, I don't think this is our bathroom, and sure enough, it was not. And they had used those cut and paste pictures on 3 different cases, so we were able to get a hold of them and their law firms that they were going to work with, and made that go away. So it's always important when you get these lawsuits to make sure you check in with legal, check in with a CAS inspector or company, and make sure that it's real. There's so many of them that are cut and paste.
Yeah, they're very cut and paste, some of them.
Yeah, some of the firms, but if that's the one you get, we want to get you out of it.
Absolutely.
Well, and one thing we've seen a lot in the last year, ever since the Domino's decision, is from a website standpoint, we've seen Colorado, Massachusetts, New Jersey, Pennsylvania, Illinois all branch out and started having a lot of lawsuits. And what's interesting and sad, actually, is I see people that are in California that have contacted us because they were sued somewhere else, and the attorneys in the new districts not being familiar with this and not giving the advice to settle this quickly. Let's see where it goes. Hire retainers and things like that. So it's really interesting to find attorneys that really understand this. And I know when you look online, sometimes it can be a bit confusing. Where should someone really go to kind of get maybe a second opinion, or to know what they should be doing if this is especially in a new district that hasn't had a lot of these lawsuits, Bruno?
Well, I think you need to, before you hire an attorney, you need to interview the attorney and ask them, pointed questions. Do your little research on do your research on the ADA and ask them, how many of these cases have you handled? What do you see? Are you familiar with this law firm? What's your understanding of the rules of the ADA? Or ask them about the Domino's decision. There's some lawyers who won't have any idea and go, oh yeah, I can handle this for you. But you need to interview the lawyers before you hire them and really get a sense of, and then ask around, ask your colleagues that maybe, have you ever had this issue? And some will share, some won't share. But who handled that for you and how did that go out? So you need to do your homework too. Don't just hire a lawyer because they say they can do it. I mean, interview them. There's nothing wrong with interviewing a lawyer to make sure that they're competent and they understand the issues and they've done this type of work before. You hire contractors, you hire other people. Before you're dealing with a major thing, you interview them, you talk to them, you get, like if you were bidding on a construction project, you don't just, oh, I'm looking in the yellow pages, I'm going to deal with, umpty schmuck construction. Get some bids, get an understanding, talk to them, see what they understand and what they do, what the process is, what permitting they have to do. Same thing with a lawyer. You can talk to them. And I've had plenty of times where I'm interviewed about issues and they talk to me, and sometimes they use me, sometimes they don't. This is kind of a specialized area. There aren't, I think speaking, lawyers don't truly understand the ADA and how to handle these issues. Some do and some don't.
Yeah, I would say that applies to our industry as well. I mean, you have some CASP inspectors that are going and they'll take a picture of an accessible parking space and it'll come back with a report that says not compliant. You want the detail of what's not compliant so that you can then help it. But some people just want to pay for that picture, says whether it's compliant or not. So you should interview and find out what additional services that you're going to get from a CASP inspector. Are they going to keep you up to the changing codes? Because they're changing, and there's a lot of new accessibility codes that are coming into effect in July. We need to get that information out. I know from the standpoint of web accessibility, Glenn, because I've talked to other people who claim that they know what they're doing with websites. And then you realize after talking, because I'm not a techie, you start talking about that stuff, smoke starts coming out of my head, as you know. And there are some that you absolutely know they don't know what they're talking about. But if you didn't know as a business, they're a great salesperson. Like, you're going to buy their item. It's got to be very tough to be in business today, and knowing who's telling you the truth. And I always say, references. Talk to people who've used that service. Talk to someone who's used that law firm, and find out what their experience was. Whenever you have to go to a law firm or get any sort of service like that, it's going to cost you. So it's going to hurt you financially. A dollar out of a pocket anymore is a lot. So you want to make sure that you're getting everything for your money. Check around, shop, have a connection with someone, and find out. So great advice for every industry right now.
Well, and there's not any accessible testing tool that's foolproof. But what I tell everyone is, these testing tools anyone can use, Google them. And if you're hiring someone to fix your website, make sure they know how to fix their own website. Because if they can't fix theirs, they probably won't fix yours. Okay, we have one last question and we'll get out of here. Brent says, should you consult with an attorney prior to having an issue? And can you recover the costs if they lose? So where you have to pay for the plaintiff's attorneys, if they lose, will they also have to pay for your costs?
No, it's a one-way street.
Oh.
It's a one-way street. And that's often the case with a lot of things. The only way you get your attorney's fees in this is if you can show the court that this in fact was a frivolous or a serial lawsuit. If you can prove that, then there's an argument you get your attorney's fees because of that. But generally speaking, it's a one-way. It's set up one way on the litigation, and I'll tell you the rationale for it, right or wrong, is that in fact, if you didn't have the attorney's fees provisions, nobody would file these lawsuits. They wouldn't feel comfortable getting a lawyer, because the only way the lawyer would agree to do it is if they get some kind of attorney's fees out of it. And that's why they build in this one-way attorney's fees. Lawsuit is to encourage people where there's actual injustices that have occurred from being able to litigate and not be concerned about having to pay them litigation. So it puts the pressure on the other side.
Yeah, and I mean, the case is if the violation exists, you know, it's a valid case.
Right.
So.
But as to, should you consult a lawyer prior to having an issue? What you should consult is an expert that understands architectural and website issues, so that you can, from a preventative standpoint, if these lawsuits come, can say, oh, no, ladies and gentlemen, here is our CASP report. Here's our CASP certification. We are 100% in compliance. And here is our website accessibility where we have been guaranteed. And if what you have someone that does the website accessibility issue and they really don't know what they're doing, then you can say, well, maybe you need to go, maybe you as the owner need to go against the web designer who certified to you that you were in compliance under the requirements, and therefore say to them, you need to pay this for me. So that happens sometimes.
Well, thank you very much for coming on and joining us, Bruno. You're always very gracious with your time. I appreciate when I've had people contacting us that you'll take some time to talk to them and help them walk them through this scary time. So if someone would want to reach out to you or have a question, what's the best way to contact you, Bruno?
Probably my email, which is Bruno, BRUNO, .Katz, KATZ, at Wilson, that's spelled like Wilson, Elzers, E as in Echo, L as in Lima, S as in Sierra, E as in Echo, Romeo.com, or you can call my direct line, which is 619-881-3317. But email always probably, at least send the email so that I know you're about to call me. So I'm not, because sometimes in this day and age, if I see a number I don't know and everything that's going on, I may not pick it up, but you can always leave a voicemail, obviously, on my direct line. So.
Thank you so much, Bruno. It is always a pleasure to chat with you. I always learn just a little bit more about the legal side of things, and look forward to seeing you again when everybody's getting back together, and I'm sure we'll talk again soon.
Well, thanks, Glenn. Thanks, Tracy, for having me. I appreciate it. Thank you.
Thank you.
All right, everyone. We'll see everyone back here next week. Same time, same place. Have a good week, everyone.
Thank you. Bye-bye.
Bye-bye.